this is unique because, again, in Florida, Judge Cannon, she has been under a constant attack by the left. But if you've seen how these other court cases have come about, I mean, let's remind you, in Georgia yesterday, the Court of Appeals yesterday stayed all proceedings in the lower court. Remember, we told you they decided to take and hear the case on whether Fani Willis should be disqualified from prosecuting the case against Donald Trump and the other defendants in that Georgia case, which at one point numbered around 16. I think it's maybe 14 now. They removed her special counsel, but they didn't just decide to take the case. They even scheduled oral argument in October, which they usually don't do. But I think at this level of case, they probably will at the Georgia Court of Appeals. And they stayed every proceeding. So we're talking about motions, any kind of movement at all. So that case now, you kind of say, okay, check that box. That one's not really going anywhere. But here, what is being challenged and what Judge Cannon is allowing to be presented oral argument by outside parties, which is also unique in this. We're seeing, too, how the ACLJ technically could get involved. We've complained a lot about the appointment of special counsels. We've obviously dealt with those directly on behalf of President Trump through our separate law firm. And again, the size of the Department of Justice, why do you need 30 extra people to put together that then spend all this extra money and extra budget? And it's kind of full of scandal. And you got to say, can they really prosecute anyways? We had all of that whole discussion, with Durham. Do they really have the power to go prosecute where they want to go? Or are they stuck? Is David Weiss able to go outside Delaware? Can he go to California? And so we've had all of those discussions. We don't have an independent counsel in the way that you knew them under the Clinton days. So that is not available. The special counsel, again, what is being challenged here is, can the Department of Justice, through its rulemaking authority, which they did, have this office which operates similar to a U.S. attorney who would be confirmed by the U.S. Senate as an officer of the United States? Can someone be a special counsel who's not? And of course, we have special counsels who currently are not confirmed by the United States as for that position, and so they're challenging specifically the choice of whether Jack Smith is actually legal. And she's allowing parties not involved in the case to present oral argument. So while the whole case is indefinitely on hold, remember the classified documents are all out of order? The government gave you the glossary back and it didn't match. Some of the documents are now missing. But we know that there will be an oral argument on June 21st on whether or not Jack Smith and his appointment is even legal.
If a U.S. attorney was handling the Mar-a-Lago case, the classified documents case in Florida, there would be no legal question with respect to his authority. In this particular case, Jack Smith was hired or appointed by Attorney General Merrick Garland. And if he is presumed to be a principal officer of the United States, he must indeed be nominated first by the President of the United States and confirmed by the Senate. That did not occur. So the argument that the Trump defendants are making is that Jack Smith has no viable authority. Indeed, the United States Supreme Court, at least in the person of Clarence Thomas, has raised a question as to whether or not these so-called special counsels are viable within the meaning of the United States Constitution. And so I think at the end of the day, this will be an important hearing, and it will indeed be a lengthy hearing. Why? Because Judge Cannon is going to hear from so many lawyers on both sides of this particular question. And so I think this is a very, very important issue. I hope that this issue ultimately winds up before the United States Supreme Court so we can decide this question once and for all.
Any other attack is just an attack on the judge herself. If you don't like the idea that she's even considering it, by the way, we don't even know how she's going to ultimately come down on this. She might not be convinced one way or the other. What I think is probably pretty clear, Harry, though, that's it's being set up is exactly what you just said, which is this is a trial where we can almost guarantee, unless she just says no and kind of goes with the past, that if she takes a position that it's unlawful, it's certainly going to be heard by the 11th Circuit. And then if the 11th Circuit issues an opinion that maybe is similar to hers, I think it's certainly going to be heard by the Supreme Court. It might take two levels for the Supreme Court to get there, but the other times it was challenged, it was thrown out so quickly there was no way to it wasn't like an appealable issue. I mean, it was just like no, and they just moved on.
This is something that we at the ACLJ have pushed back against for decades, and that is the rulemaking process and the regulatory process within bureaucracies as opposed to legislation by Congress. So the special counsel office and authorities come out of the Code of Federal Regulations, which is the rulemaking process, and they rely on a part of the U.S. Code, which would be legislative, that allows the Attorney General to delegate some of his authority. That specifically says to any other officer, employee, or agency of the Department of Justice. But the interpretation of the law by the bureaucracy takes it much further, and actually it raises questions of whether people like John Durham or Weiss, the special counsel that is prosecuting Hunter Biden, are actually within the rules allowed to be special counsels, because the provision says it needs to be someone outside of government, which automatically sounds like it sets up a constitutional issue on whether the regulations are relying on U.S. code to say it has to be someone who is not a part of the government. And yet we also have two special counsels that have been a part of the government in recent history. Do you think that this shows, one, the terrible nature of the rulemaking process that we're struggle with when we have bureaucracies making this, but also it gives a lot of holes that a higher court could poke?
I think that's precisely correct. And so it's a wonderful issue for appellate courts. It's a wonderful issue for the United States Supreme Court. It's a wonderful issue for law professors. So at the end of the day, however, the bottom line is you are absolutely correct, Will, that the rules were imperfectly drafted and there are gaps, and lawyers like to use fancy words like lacuna to indicate that there are gaps in the rules and regulations, and this needs to be filled in by the court. So ultimately, this case should result in a United States Supreme Court hearing and decision-making to clarify this particular issue.